Good morning and welcome to today's webinar on Inheritance Act claims. This is the 5th webinar in a series of webinars that we've been running this year on contentious probate claims. For those of you who don't know me, my name is Ali Toe. I'm one of the senior associates in the dispute resolution group here at Boyce Turner, and I will be hosting today's webinar. This is a live webinar, so please feel free to post any questions you may have as we go along through the chat panel. This webinar may raise a number of questions, so please bear with me. I will try and answer your questions at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you separately. Although live, today's webinar is in listen-only mode. However, as I say, you can send us any questions or comments that you may have through the chat panel, and I will do my best to answer as many of them as I can at the end of the webinar. So as I say, today's webinar is the 5th in a series of webinars that we've been running this year on the question of contentious probate claims. We've already covered lack of testamentary capacity and wanton knowledge of approval of wills, undue influence and forgery of wills, rectification of wills, lost wills and deathbed gifts, proprietory estoppel claims, and as you can see on the slide, next up will be the removal of executors and administrators. But as I say, today we're going to focus on the question of Inheritance Act claims, so let's get started. Before turning to the Act itself, it's important to consider the question of testamentary intention. In England and Wales, testators retain the freedom of testamentary intention. This means that in principle, you are free to leave your estate to whoever you choose. However, that is subject to the provisions of the Inheritance Act. The Inheritance Act, or to give it its full name, the Inheritance Provision for Family Independence Act 1975, provides statutory protection for those individuals in respect of which there is an expectation that adequate provision should have been made for them under a testator's will, or if no will has been made by virtue of the intestacy rules, but in fact no such provision has been made. The Act limits the scope of the persons who can apply by setting out various classes of applicant who have the right to do so. These are set out in section 1 of the Act and are as follows. The spouse or civil partner of the deceased, a former spouse or former civil partner of the deceased, but no one who has entered into a subsequent marriage or civil partnership, any other person who was living in the same household as the deceased during the whole of the period of 2 years, ending immediately before the deceased's death, a child of the deceased, any person who was treated by the deceased as a child of the family, and any other person who immediately before the deceased's death was being maintained either wholly or partly by the deceased. So having established that the applicant has the right to bring the proceedings, what then can they do in terms of the claim itself? In order to be successful with a claim, any applicant will need to demonstrate that the deceased will, or the rules of intestacy if there is no will, does not amount to reasonable financial provision for them. Now that might be because no provision has been made at all, or that the provision that has been made is not adequate. There is a different test for what amounts to reasonable financial provision for any spouse or civil partner and any other applicant. In the case of a spouse or civil partner, reasonable financial provision is defined in the Act as being such financial provision as would be reasonable for them to receive in all the circumstances of the case, whether or not that provision is required for their maintenance. Conversely, in any other case, reasonable financial provision is defined in the Act as being such financial provision as it would be reasonable in all the circumstances of the case for the applicant to receive for their maintenance. In all cases, what is reasonable financial provision will depend upon the facts of the case. Whilst each case does turn on its own individual facts, the Act does provide some guidance on matters to which the court shall have regard when considering any claim. So let's have a look at that guidance in section 3 of the Act, and is as follows. The applicant's financial resources and needs, any other applicant's financial resources and needs, any beneficiary's financial resources and needs, any obligations and responsibilities which the deceased had towards any applicant, the size and nature of the deceased's net estate, any physical or mental disability of any applicant, and any other matter, including the applicant's conduct or any other person, which in the circumstances of the case, the court might consider relevant. No one guidance point is more important than another, and it's a question of the court carrying out a balancing exercise having regard to all the guidance points in order to ensure a fair award is made, if appropriate, to the applicant. This can be very difficult, particularly in claims where the estate is of modest value and in circumstances where there may be competing claims, such as a spouse and cohabitee, or a spouse or cohabitee and children. Whilst no one guidance point has any greater priority or importance than another, it is often the case that many claims will fall to be determined having regard to the applicant's financial resources and needs and those of any other applicant, together with the size and nature of the deceased's estate. One often finds that it's easier to resolve these cases where the estate is higher value, as there is more money to go around. The difficulties usually occur with the lower value estates, particularly if there are competing applicants. Inheritance Act claims must be brought within 6 months of the date of obtaining a grant of probate or letters of administration if there is no will. However, it's not necessary to wait for a grant to be obtained before bringing the claim. Section 4 of the Act does provide for time to be extended in exceptional circumstances, but this is a matter for the court's discretion, so there is a risk of the court refusing an extension. Applicants would be best advised, therefore, to ensure claims are issued within the primary limitation period of 6 months. Given this short limitation period, it is imperative that applicants give consideration to the possibility of a claim sooner rather than later, and make contact with the deceased executors or administrators at the earliest opportunity. If proceedings cannot be issued within the primary limitation period, it is in theory possible for applicants to enter into what is known as a standstill agreement with the executors and beneficiaries of the deceased estate. Standstill agreements are agreements reached between the parties which suspend time for the purposes of limitation during the subsistence of the agreement. Standstill agreements have regularly been used by lawyers for many years, both in commercial and family disputes, without any difficulty. However, doubt has recently been cast upon these, following the case in 2019 of Cowan and Foreman. In that case, Mrs. Cowan had entered into a standstill agreement with the executors of her late husband's estate. Whilst this had no direct outcome on the initial determination of her application by the Family Division of the High Court for an extension of time, which was refused, Mr. Justice Mostyn suggested in his judgment that the use of standstill agreements should come to an immediate end because it was not for the parties to give away time which belonged to the court. Whilst the suggestion is not binding authority, applicants would be wise to avoid relying on a standstill agreement, and certainly may now do so at their peril. I should say that Cowan and Foreman was subsequently appealed, and Mrs. Cowan was granted an extension of time to bring her Inheritance Act claim. It's also the case that many Inheritance Act claims can be settled without the need to issue proceedings. So as I say, it's always good to put the executors or administrators on notice of any claim sooner rather than later. But if proceedings do have to be issued, they are brought pursuant to the provisions of Part 8 of the Civil Procedure Rules 1998. They must be issued in the High Court in either the Chancery Division or the Family Division. There is also provision under Section 5 of the Act for an interim order to be made where the applicant is in immediate need of financial assistance pending the outcome of the proceedings as a whole. So, having established that the applicant is within a category of class who can bring a claim and issue proceedings, what then can the applicant expect in terms of relief? Well, let's have a look at that. The court's primary intention is to try to achieve a fair and reasonable order for all concerned. As I've said, this can often be difficult, but the court will use all remedies available to it in order to try to do so. To assist, the Act does provide quite wide powers as regards potential awards that a court may make. These are set out in Section 2 of the Act and include the following. An order that the estate should make periodical payments to the applicant at such rate and for such period as the court considers fit. An order that the estate make a lump sum payment to the applicant for an amount to be determined by the court. An order that such property as identified by the court should be transferred by the estate to the applicant. An order that such property as identified by the court as being appropriate should be purchased by the estate and transferred to the applicant's sole name. An order varying any antenuptial or postnuptial settlement agreements. An order varying any trust arrangements in place in relation to the deceased estate in the applicant's favour, and an order varying any settlement arrangements made during the subsistence of a civil partnership by the deceased or in anticipation of the formation of the civil partnership by the deceased. So what does this all mean in practice? Well, let's look at a few cases involving some different scenarios. First of all, Ubi and Ubi. This was a case involving minor children, which was decided in 2019. Mr. Ubi was married to Susan. When they met, Susan already had a young daughter, Jessie, aged 1. Mr. Ubi treated her as his own daughter. They also had a son together, Jarnell. By the time of Mr. Ubi's death, Jessie was 31 years of age. However, she had struggled to gain independence following a horrific hammer attack at the age of 17, and as such, she continued to live at home. Jarnell, who was born in 1994, also had health difficulties, including learning difficulties. Both children continued to be supported by Mr. Ubi at the time of his death. Susan and Mr. Ubi had met in 1987 and married in 2000. Throughout the existence of their relationship, they had grown Mr. Ubi's business, a pharmacy, and also acquired various properties. However, Mr. Ubi also had 2 other minor children with Bianca, a fellow pharmacist with whom he had been having a long-standing affair, Mattia, aged nearly 3, and Gabrielle, aged just 1. Bianca and Mattia had initially lived in a 2-bedroom property purchased by Bianca from her own financial means. However, in 2013, about 6 months before Gabriel was born, Mr. Ubi arranged to move Bianca and Mattia into one of the properties he owned jointly with Susan. Shortly thereafter, Mr. Ubi left Susan and took up residence with Bianca. Mr. Ubi continued to maintain Susan and their children, as well as Bianca and their children, until his untimely death in February 2015. By his last will, made in 2010, and therefore before the birth of both Mattia and Gabriel, Susan was the sole beneficiary of Mr. Ubi's estate. Bianca's children were clearly in a class of category who could make a claim under the Inheritance Act, and as no provision had been made for them at all under Mr. Ubi's will, Bianca brought a claim on their behalf under Section 2 of the Act, seeking a lump sum payment for their ongoing maintenance. Whilst Susan accepted that Bianca's children had a valid claim against the estate, the parties could not agree on what this meant in financial terms, and accordingly the matter came before the court with poor resolution. This case is an example of where the court has to balance matters to take effect of competing claims. On the one hand, Susan and her children, who although not minors, remained dependent on Mr. Ubi at the time of his death, and Bianca's children on the other hand. Bianca herself did not make a claim since as a qualified pharmacist, she had her own income and was not being maintained by Mr. Ubi at the date of his death. Indeed, Bianca accepted that she was able to maintain the children's ongoing lives herself, in part from her own income. However, she could not fund the entirety of their financial needs, and it was in this respect that she sought a lump sum payment. Firstly, the court had to consider the children's housing needs. They could not continue to live in the property where they were currently housed, as this was a property which had belonged to Mr. Ubi and Susan as joint tenants. Accordingly, it had now transferred to Susan under the doctrine of survivorship rights. In addition, there was the question of financial assistance to meet the children's other financial requirements, including the payment of school fees, once they were of school age, and childcare costs, which Bianca could not fund solely from her own income. The net value of Mr. Ubi's estate was about £3.5 million. The court recognised that a large proportion of it related to properties and the value of the business which Susan and Mr. Ubi had been instrumental in amassing during their lives together. Having regard to this and Bianca's ability to part fund the children's ongoing financial needs herself, the court ordered that the children be awarded a lump sum of just over £386,000. And then in the Eilert and Mitzen case, this is a very important case for several reasons. Firstly, it went to the Supreme Court. Secondly, it involved a claim by an adult child. And thirdly, the defendants were charities. Given the current financial economic climate that we're living in, charities are keen to ensure that they preserve any entitlement under wills. So this was a case decided in 2016, as I say, involving an adult child. Mrs. Eilert was the only child of Mrs. Jackson, the deceased. In 1978, when she was only 17 years old, Mrs. Eilert left home to live with her boyfriend, who Mrs. Jackson did not approve of. Mother and daughter were estranged for the next 26 years, although there had been some attempts to reconcile throughout the years. Mrs. Jackson's husband had died when she was pregnant, and she had no other living relatives. Mrs. Jackson died in 2004. By this time, Mrs. Eilert was married to the man she had left home for, and they had 5 children together. They had lived their lives entirely financially independent from Mrs. Jackson, and in the main in complete isolation to her. In 1984, Mrs. Jackson executed a will. She made no provision for her daughter in the will and recorded her reasons for the same in a letter of wishes. She reiterated this position and her wish that her daughter should not receive any of her estate upon her death when she executed her last will in 2002. Again, she left a side letter setting out her reasons as to why she had made no financial provision for her daughter. Instead, Mrs. Jackson chose to leave her estate to charities. Mrs. Jackson's estate, which comprised mainly of her home, had a net value of approximately £486,000. Mrs. Eyelet's financial circumstances were modest to say the least. The family lived in rented accommodation provided by a housing association. 4 of the children were still living at home, although one of them, aged 20, was in full-time employment. Mrs. Eyelet had elected since the birth of her children to remain at home and was not employed save for a small income as her husband's bookkeeper. Her husband had intermittent work as an actor, earning about £4,000 per annum. The rest of the income, aside from a small amount of housekeeping paid by the 20-year-old son, comprised child benefit and working tax credit, which equated to about £10,000 per annum. The family also received housing benefit and council tax benefit, which together were worth about £5,000 per annum. Overall, the family's net income amounted to about £20,000 per annum. The family had lived on that income for many years. They were not insolvent. Indeed, they had a small amount in savings, about £4,000. They lived within their means, but the clear evidence was that they were distinctly limited in what they could do. Their household equipment was old and much of it worn out. They were in desperate need of a new car, and they needed new carpets and other decorative things for the house. They'd never had a family holiday and could not contemplate any extracurricular activities for the children, such as music or sports lessons. Mrs. Eyelet was entitled to buy her present home at a concessionary price of £186,000. This figure later fell by the time of the Court of Appeal judgment to £143,000. Accordingly, Mrs. Eyelet made a claim under the Inheritance Act on the basis that her mother's will made no financial provision for her, and she sought an order for such financial provision as it would be reasonable in all the circumstances for her to receive for her maintenance. At first instance, the district judge found that Mrs. Jackson's will did not make reasonable financial provision and awarded Mrs. Eyelet the sum of £50,000. Mrs. Eyelet was not happy with that amount, as she was seeking capital provision amounting to at least one half of her late mother's estate, and so she appealed the district judge's decision. The charities, as beneficiaries of Mrs. Jackson's will, also cross-appealed, challenging the conclusion that there had been any failure of reasonable financial provision. The appeal came before Mrs. Justice Eleanor King, as she was then. She concluded that the district judge had erred in law or principle in asking himself whether Mrs. Jackson had acted reasonably rather than whether there had been a failure to make reasonable financial provision, and that he should have held there was no lack of reasonable provision. She allowed the charity's cross-appeal, and as such, there was no need to consider Mrs. Eyelet's appeal. Mrs. Eyelet appealed to the Court of Appeal. The Court of Appeal held that the district judge had not made the error as claimed, and Mrs. Eyelet's appeal succeeded. The Court of Appeal remitted the matter back to the High Court as to the amount of the order. That appeal then came before Mr. Justice Parker, who upheld the district judge's order. Mrs. Eyelet therefore appealed this decision as well. The Court of Appeal, considering the matter for a second time, held that the district judge had fallen into 2 errors of principle in arriving at his award of £50,000. It proceeded to make its own evaluation of the claim and awarded Mrs. Eyelet £143,000 to buy her home and an option to receive a further £20,000 in 1 or more instalments to provide a small additional income. The order was specifically formulated in such a manner as to mean that it would not affect Mrs. Eyelet's benefits. The charities then appealed that decision, and the matter finally came before the Supreme Court. The Supreme Court found that the district judge did not, on fuller analysis, make either of the 2 errors on which the Court of Appeal relied when it revisited his award. That, said the court, was sufficient to allow it to set aside the Court of Appeal's order, which it duly did, restoring the original district judge's order. So ultimately, Mrs. Eyelet only received the sum of £50,000, although no doubt the costs of these proceedings considerably outweighed that sum. And then in Lewis and Warner, this was a case involving a cohabitee. This claim started off life as a possession claim. Mr. Warner was 91 years of age. He had been cohabiting with the deceased in a property owned by her some 19 years prior to her death in May 2014. He wished to continue living there, but Mrs. Lewis, the deceased daughter and sole beneficiary under her estate, was not agreeable to this unless he was willing to buy it from the estate for £425,000. Mr. Warner was of significant means, although in poor health. However, he considered this sum to be an overvaluation of the property's actual worth, and so he refused to buy the property on this basis. Mrs. Lewis therefore brought possession proceedings against Mr. Warner, seeking to evict him from the property so that she could sell the same. Mr. Warner defended those proceedings and issued a counterclaim under the Inheritance Act on the basis that he fell within the category of classes of claimants entitled to do so because for a period of 2 years prior to the deceased's death, he had lived in the same household as her and as her husband. At first instance, the court ordered that the house should be transferred to Mr. Warner. The court found that by maintaining a roof over Mr. Warner's head, the deceased had provided him with maintenance, which had a financial value. Therefore, the failure of the deceased's will to allow that to continue meant she had failed to make reasonable financial provision for him. Taking account of Mr. Warner's physical disability, age, the length of time that the property had been his home, the contributions he had made to the cost of the property during that time, and the fact that the property was located in a village where he had lived all his life and next door to neighbours who cared for him, the court was satisfied that the property should be transferred to him. Balanced against that, however, the court agreed it would be unreasonable for Mrs. Lewis to have to wait until Mr. Warner's death to realise the value of the property, and so it ordered that Mr. Warner should buy the property for £385,000. Mrs. Warner wished to sell the house to the highest bidder, whether that was Mr. Warner or someone else. She was not happy with the order and sought to appeal the same. The matter came before Mr. Justice Newey, who dismissed her appeal. He confirmed that maintenance is not defined in the Act, and a person can be in need without being short of money, where money cannot secure them what they require. In this case, the continued occupation of his home. Mrs. Lewis appealed to the Court of Appeal. Sir Geoffrey Voss, in delivering the leading judgment of the court, concluded that the issues in the case focused on two central questions. Firstly, whether the court was right to conclude that the deceased will did not make reasonable financial provision for Mr. Warner's maintenance. And secondly, whether the court was entitled, as a matter of law, to make the order that it did under the Act. Voss confirmed that the court was fully entitled to reach the conclusion on the evidence that the deceased will did not make reasonable financial provision for Mr. Warner's maintenance. The court had found that Mr. Warner was being maintained by the deceased in that she was providing a roof over his head and that he needed that maintenance to continue. Voss went on to conclude that the court had properly balanced the interests of Mrs. Lewis against Mr. Warner's claim before concluding that his needs, not his wishes, outweighed Mrs. Lewis's interests. As to the order made and whether the court was entitled to make the order as a matter of law, Voss dismissed the argument put before the court by Mrs. Lewis's advisers that by Mr. Warner paying full value for the property, this did not amount to reasonable financial provision for his maintenance, on the basis that it was common ground an order requiring for the transfer of a house in return for some financial consideration could be made under the Act. If, Voss said, it is maintenance to provide a house for someone in Mr. Warner's position, the exact purchase price does not matter. And then finally, in Lilliman and Lilliman, a case decided in 2012, Mrs. Lilliman made a claim against her late husband's estate, following his death, when it emerged that he had left almost the entirety of his estate to his sons from a previous marriage. Mr. Lilliman's will did make some financial provision for his wife, including the transfer of some chattels and gifts, together with a conditional right to occupy the former matrimonial home and a holiday home. She was also entitled to receive an annuity of £327 per month. This, however, Mrs. Lilliman contended, did not amount to reasonable financial provision. Mr. and Mrs. Lilliman had had a very short relationship, only some 4 years in duration, with the marriage itself only being 2 years. However, Mr. Lilliman's net estate was valued at approximately £6 million. Mr. Lilliman's sons argued that reasonable financial provision for Mrs. Lilliman should be determined by reference to her reasonable needs, whereas she, on the other hand, argued it was not limited to her needs, but meant a substantial share of the matrimonial property. The court had to undertake a review of non-matrimonial and matrimonial property. Non-matrimonial property, namely assets that the husband already owned prior to the marriage, included his 3 companies, which were worth in excess of £5 million. His sons worked for these companies, and they provided their source of income. Matrimonial property included the home where Mr. and Mrs. Lilliman lived, together with a second home bought for them, which together had a value of about £700,000. There were also some savings and shares in unit trusts valued at about £600,000. Having considered the position, Mr. Justice Briggs awarded Mrs. Lilliman the sum of £500,000 and also ordered that the matrimonial home and second home be transferred to her sole name. In doing so, he noted that this would provide financial security, including as to accommodation, for her for the rest of her life. So that's just a few cases that demonstrates how the court approaches Inheritance Act claims depending on the category of applicant, and that therefore concludes this webinar on Inheritance Act claims. My contact details are on the slides, but for now it just remains for me to say thank you for listening and to say I look forward to welcoming you to our next webinar next month, which is on the 9th of October, and when I will be looking at the removal of executors and administrators. So look out for more details about how to register for that shortly. In the meantime, once again, many thanks for listening. Thank you and good morning.